been doing this. This is my 7th year practice, and I started out doing estate planning as a big part of my practice, and then sort of developed this little niche area of pet trusts and planning for people who have pets and what to do after they pass away. So what I like to do is start with my favorite example that I always use is in 2007, the very wealthy woman named Leona Helmsley who passed away. She received her wealth, I believe, from the hotel industry, and in her will and her trust, she spurned many of her relatives, and she said, "I'm not giving anything to you." She did give to a couple people, but then she left $12 million to her dog, which was a white Maltese named Trouble. And originally, Leona's brother was named as the caretaker of the dog. The caretaker, he didn't want to handle the responsibility. So the dog was actually flown in a private jet down to Florida by itself in its own jet, where it lived out its days at the Sandcastle Hotel in Sarasota. It was tended to around the clock with all this money available to provide for it, an annual budget of over $100,000, which included a 24-hour security presence for the dog as well. So I guess they were worried about some of the spurned relatives, wanting to hurt the dog or something. So it was given this security presence. But the document she used to create this was a pet trust. And so a basic understanding of what that pet trust is it's a mechanism by which someone can provide for their pets after they have passed away. And it names a couple different people. One thing it names is a caretaker, who actually handles, quite literally, taking care of the pet or pets. There is also a trustee that is named. And the trustee handles the finances relating to the pets. So the finances then are used to pay for the pet's expenses, veterinary bills, food, boarding, things like that. And then once either the pet or pets have all passed away, the remainder of the trust is then distributed according to however the grantor set it up. The grantor meaning the person who created the trust, okay? So oftentimes people, when they first hear about this, sometimes they're a little skeptical about, is this recognized under the law? And the answer is yes, that it is. We have the Illinois Pet Trust Act, which was passed several years ago by the Illinois legislature, and it basically says that we will recognize any trust created for the benefit of a domestic pet animal. And these trusts are also recognized in almost every other state as well. In fact, last I checked, 49 out of 50 states have recognized pet trusts, except for Minnesota. Don't know why, it's the one random state that doesn't have it, at least last time I saw. But if you were to create a trust here and move to another state, it would still be recognized under their law as well as ours. Now, the other thing is that what animals are covered under the Pet Trust Act is very broad. It says any domestic pet animal. Okay, so it could be anything from just basic dogs and cats to the more exotic ones, basically any animal that you might keep at your house, also including things like horses. Okay, so it can provide for sort of the non-traditional pets that we have, but it does provide for those. So the first thing you want to look at is who's going to be the caretaker if you decide to create a pet trust. The most important qualification is that you want someone who is willing to take on that responsibility. So you want someone who is also familiar with your pets, familiar with the care that they need, and has expressed some desire to be able to carry out these jobs, because all of a sudden if someone doesn't have any animals and then all of a sudden they're in charge of one or more animals, it can be a little bit of a shock if they're not prepared for it. So you want someone who is willing to do that. I usually recommend that you talk, if you're thinking about setting up one of these such trusts, I usually recommend you talk with someone that you have in mind first to gauge their interest, to make sure that they'd be willing to take on this responsibility if you should pass away. And then I also usually recommend that people name a contingent caregiver as well. So someone who could serve as a backup in case your first person either declines or has already passed away at the time that you die.
Can I ask a question?
Sure.
In the intro story that you gave,
Mm-hmm.
the caretaker did not want to take care of the dog.
Correct.
So, if in that case, is it the trustee who determines who the caretaker is, or how does that work?
I don't know, because without actually getting to see the documents itself, usually if there is a contingent provision in place, it'll default to the next person, whoever it is, and then the animal will go to that secondary caretaker. If not, then it usually falls on the trustee to find an appropriate caretaker.
Okay.
So either finding a person or a corporate trustee or an animal shelter or something like that that can handle the pets.
Okay.
And so, speaking of the trustee, they're in charge of handling any finances associated with the animal, and they will manage those distributions to pay for all the animal's needs. They will also are responsible for investing any money if it's a very large trust, and so you don't have just a whole bunch of money sitting in one checking account. They're responsible to at least invest it responsibly so that it can hopefully accumulate some earnings over time. Now the caretaker and the trustee, depending on people's wishes, it can be the same person, but it doesn't have to be. So oftentimes people want there to be some sort of checks and balances in place. And in that case, you might have one person being the caretaker where they have the animal, and the trustee is someone completely different who is overseeing the funds. If in some instances where people do want the caretaker and the trustee to be the same person, that person is in charge of pretty much everything relating to the trust, and they have a lot of power. Under our law, we are also allowed to name what's called a trust enforcer. And the trust enforcer essentially addresses the issue of standing. So, say for example, I have a friend, and I know this person is the trustee of a trust, whether it be a pet trust or just a living trust, and I know that they're not doing their job appropriately. They're not handling the money properly. If I'm not a trustee, a successor trustee, or a beneficiary of that trust, I don't have what's called standing to bring that person in front of a court to either have them removed or to ensure that they do the appropriate accountings. So you can also name this trust enforcer if you wanted to, but usually if you're going to name caretaker as one person and trustee as another, you don't need the trust enforcer. But it's just one thing to think about. If you are thinking about creating a plan, there's a few things that usually I recommend people to think about ahead of time. Specifically, the needs of your pets, including how much their vet bills are, how much they expect to be, how much you pay on grooming and boarding, and also the life expectancy of any pets that you may own. Certain pets, like some birds, can go on to live for a very long time, usually far beyond what an average dog's life is, for example. So what I'll tell you a little story of how this is relevant to me personally. I have 2 dogs at home. Okay, my oldest dog is her name is Bailey, and she's an Australian Shepherd mix. She's just a mutt. We got her from a shelter. She's the most chill dog ever. She's so laid back, and she never has any health problems whatsoever. Just this perfectly healthy dog. And then our other dog is a purebred Basset Hound named Gus. And Gus has a slew of issues. He's the sweetest dog ever, but he's got all kinds of problems, including glaucoma that he developed. He actually had to have his eye removed, one of his eyes removed, and now his other eye, we have to give drops 4 times a day to keep that other eye, because it's primary glaucoma, and essentially he will lose the sight in his other eye eventually. So he's very, very high maintenance. You don't even want to know how much it costs to have an eye removed, because it's quite a bit of money. Thankfully, we have pet insurance as well to help cover some of those veterinary bills. But just looking at, my 2 dogs, I see, obviously Gus is going to need a whole lot more care than our other dog. So you try to think of that. What I encourage people to do is actually go back and look at how much you actually spend on your pet's care in any given year. And if you're an animal lover, you probably don't want to admit actually how much you actually spend on your animals, because it's probably more than you'd like. But we do it because we love them, and so we always want to provide for them. The other thing to consider is something else that you could put in these documents is what would you want to have happen once that pet subsequently passes away. Not just with the pet itself, as far as the remains, or want it to be buried in a certain place or something like that, but then what happens to the remainder of the trust assets. So those will be distributed however you want to set them up. Oftentimes people will want to give them to charity, or want it to revert back to some of their own family members. This is also assuming that the trust assets have lasted that long, because if people don't properly prepare and don't properly fund the trust itself, it's only going to last a certain amount of time, depending on how expensive the pet is to take care of. And if the pet has extraordinary medical bills, like my Gus does, then that money might go through faster than you might think. So, any questions so far on anything? Sure.
Another question. Can the trustee is specific as to say how you want your pet treated if they get like a chronic condition that will lead to death? I mean, some people want a lot of intervention and veterinaries, and other people are more like consumed. Well, I'm sure we're all consumed with quality of life. Mm-hmm. In my case, sometimes I think, well, I just want to keep the pet comfy, and I don't want to have them go through a lot of stuff.
Right. So the issue then becomes sort of quality of care, quality of life, and the short answer is yes. You could pretty much put in these documents almost anything you want. Mm-hmm. I mean, there really isn't much restriction as long as it doesn't violate some kind of law. Okay, so you can't put in some provision that's illegal or something, but otherwise you can exert a lot of control essentially beyond the grave. You can state any number of things as far as what your preferences are for the pet's care, preferences for where the pet lives, preferences for boarding if you're against certain places, or whatever. Any of these things can be included and be part of your wishes. Now, some of them, depending on how, some people could be a little eccentric with their wishes, and so some of them are maybe not as enforceable, not as easily enforceable as others, if they're very sort of odd requests or something like that. But for the most part, yes, all of those things can be included and named as part of the trust. Okay. Any other questions for that? So the next thing to consider is, what's the mechanism to actually set this up? Okay, and there's a couple different ways that you can do it. One is by setting up a living trust. Okay, so basically this is a trust that you establish during your lifetime. And when you have a living trust in place, it is its own entity, almost like a corporation is its own entity. It can hold property, it can hold assets, and usually the person who sets it up is not only the grantor as the person setting it up, but they're also the trustee while they're alive. So they handle the assets until they pass away, in which a successor trustee then takes over. The other way to do it is in your will. If you create a will, you can establish what's called a testamentary trust. So what that does is it sets up a trust immediately upon your death. So then it's not created during your lifetime, but once you die, it'll say, okay, I want to set aside X amount of dollars to be put in an account for the benefit of my dog, and this person is going to be the trustee, this person is going to be the caregiver, and the instructions are within the will itself. Then the third way to do it is within the will, but without the trust provisions, but where you just do specific bequests, okay? Because animals and pets are looked at as viewed as being personal property under the law. So you can give your personal property to anybody you want. You could say, I give my dog to my sister. And you can, if you do an outright gift, you can also do an outright gift of money and say, I give for, as my gratitude for taking this animal, I give X amount of dollars to use for taking over that. When you do it that way, instead of actually setting up a trust, the moment that money is given, you lose all control. That essentially, when they receive it, they can do whatever they want with it. There's no oversight, there's no trustee, there's no enforcer, it's just, you are totally trusting that the person you're giving your animals to are going to properly take care of them and properly handle the money if you don't set up the trust. So the next thing is, why is it important to do this? A couple reasons. One is that if there is no trust or no plan at least set up in place, there is a high probability that the animals that you own upon your death will end up in a shelter or that you may or may not like, okay? Sometimes people have very strong feelings as far as going to no-kill shelters or the opposite, and so usually what would happen is that you need essentially a family member to step up and volunteer to be willing to take on the animals if you hadn't set it up ahead of time. The responsibility would fall on the executor of your estate. So whoever opens up your estate and is handling the transition of your estate assets and selling your house or selling your items, they're going to be the person in charge of finding a home for this animal. Now, sometimes where we run into problems is that the person who you might have as an executor might be very good at handling money, might be very good at paperwork, not necessarily very good at handling a high maintenance Basset Hound. So those are sort of the conflicts that we see sometimes. It also, if you just state flat out in your will that I want to give my dog to my sister with no monetary compensation whatsoever, that person now has a financial burden, because now if they take the dog or whatever animals, they have the responsibility to care for them, and now they're paying out of their own money, their own pocket, to make sure that the animal's provided for. If one misconception is that sometimes people think you have to have a really large estate in order to set something like this up, and that's not the case. At a minimum, what I usually recommend is that people at least have some type of plan with their friends or family members, someone who can be just a go-to person and at least take an animal like in the immediate time after your death, maybe until a more long-term suitable home can be found. If there is no one in your life that you think would be willing to take your pets, you can also name that they be turned over to an organization like the Humane Society or a specific shelter. They can also do that as well. That can be put in there. And then also is the cost of drafting these documents and putting them together varies dramatically depending on what someone's wishes are. If you want to be like Leona Helmsley and have, a super long list of requirements and budget and everything like that, that'll cost way more money to set up than if you just want to say, I want X amount of dollars to be set aside for my pet, and basically be very simple and usually leave it up to the discretion of the trustee and the caregivers, because you've talked to them, because you trust them. Another point to make is that you can set up these instruments to care for any pets you own upon your death. It doesn't have to be specific to the pets that you own right now. You can set it up, any trust, in such a way that says, this will be set for the benefit of any pets or animals that I own upon my death, okay? So that way, if you set it up now with your current pets in mind, there's a chance you're gonna outlive your pet, and then if you were to get another one, that one would still be covered. You don't have to go back and update your documents every time, one of your pets passes away or you accumulate a new pet. So the one other thing I wanted to mention is the sadder instance that I've seen, which is, and this is more of a gray area in the law, is what happens in the event of incapacity. This has become more of a unclear issue. And what I mean is this. The example is, say you go on vacation and you leave your pets boarded at a PetSmart Pets Hotel or something. And while you're on vacation, you're in a serious car accident. And you're now in a hospital and you have either brain damage, or you're unconscious and you can't make your own decisions anymore. You can't take care of your own affairs. This can also occur because of not just like an accident, but also dementia, or the effects of old age sometimes. In this case, what happens to those pets that are at the shelter? And this is where it gets really kind of dicey. So if you have a power of attorney in place, the power of attorney in theory would be able to handle any care for the pets that was necessary. So, because the power of attorney establishes an agent for someone that you name to be able to make, and this would fall under the financial power of attorney for property, in which you name someone to be your agent to make and handle property decisions for you if you're incapacitated or if you are unable to do so. And that would be great if everybody had a power of attorney set up in place. If you don't, it gets messier. Because if you don't, essentially what has to happen is there would need to be a guardianship in place. One of your relatives, next of kin, someone would have to go to court, petition to become your guardian, your legal guardian, and then once you have that in place, then you have the ability to take care of the pets. But in some circumstances, unfortunately, like some of the ones I've seen, is that the person doesn't quite have enough funds to be able to take care of the pets, or their medical bills are eating up their entire estate. So whoever's serving as guardian doesn't place the same emphasis on caring for the pets as they do of making sure that the person themselves is cared for and that they have long-term future protected. So sometimes in that case, the pets either get pushed to the side or they get turned over to a charity or an animal shelter or something like that. And usually that's not what the people want to see have happen with their pets. If in some cases, and one thing I'm actually going to start doing myself, because someone told me and I thought it was a good idea, which is to keep some type of document, maybe in your wallet or something, that would say, because I've always thought of, what happens if I'm out and I'm in a car accident, and my dogs are home and they're locked up. What's going to happen? How long would it take for the authorities or my family to be able to go there and get them and make sure they're fed and everything. I mean, so what, I've talked with one of my friends who's gonna serve as my, like emergency dog contact person. So that way, if anything happens to me, this person will be contacted. That person has a key to my house, can go and get my dogs and at least get them in the like right away. So that way, as soon as something bad happens, because a lot of time when you're talking about estate planning and you're dealing with assets and stuff like that, there's not necessarily a need for immediacy. You don't have to act on certain things right away, but that's not the case with animals. They can't go just an infinite amount of time without food and water and walks. I mean, so those are some of the things that I recommend that people do. And so, but in addition, what you can also do is if you set up your estate planning, you could set up your power of attorney. So it also provides the person's ability. You can either, it's generally implied under the Illinois statute forms that the person has the authority to handle your pets, but you can also specifically add it and make it as one of the powers that are listed, because when you fill out the power of attorney form, there's a whole bunch of powers that are listed to handle everything from real estate to stock to filing your taxes. But you could also add any provisions relating to your pets or handling any assets associated with any pet trust you may have already set up, if you have. Any other questions so far? The one thing to consider as well is how are you going to fund any such trust if you decide to set one up? And oftentimes people, when they don't know when they're going to pass away, and they don't know how much money they're going to have when they pass away. So sometimes if you say, I'm going to set aside $10,000 for the benefit of my animals, that might be either a very small portion of your estate, or it could be the majority of your estate, depending on your financial circumstances at the time that you die. One way to protect from this is we could put any sort of alternative provisions in there in place that say, I give 10%, I give $10,000 or a certain percentage of my estate, whichever is greater, or whatever your wishes are at the time, so that way it'll provide for you in case there are any sort of deviations among your wealth and that occur over time. I mean, with everybody saw in 2008 when everyone's retirement accounts went way down and people had a lot less than they had, in 2007. So at the time that you die, you don't know where you're going to be and where the market is going to be as far as what all of the assets that you own. So that essentially covers everything that I know about pet trusts and everything that there is to know as far as the basics of it. I generally don't go into the full, estate planning as far as all the other documents. But if people have any questions or specific items as far as any other documents they wish to set up, I'm happy to answer any other questions if anybody has. But essentially that's the presentation as far as pets are concerned and with how to set up. Sure.
Could you go over the 3 actions for clearing for your pet? There was a living trust, and then there was a testamentary.
Right. So living trust, there's a testamentary trust that's created within your will, and so it's created at the moment that you die. And then there's an outright bequest in your will, where there's no trust provisions. It's just I give my animals to a certain person, and either I give them money to help or I don't. And with that provision, there's no oversight.
Okay. So what would be the difference, what would be pros and cons between the living trust and the testamentary trust?
Generally, a living trust is going to be a little bit more expensive to draft because there's more work as far as the attorney is concerned. The living trust might not totally be necessary depending on the assets that you own. Usually I only recommend people a living trust if they have assets that are usually over $100,000 and they own real estate or they have any other significant assets. But if it's someone who is not quite at that point in their life and don't have those certain level of assets, it usually doesn't make sense to do a living trust. So oftentimes it just depends on the person or the couple and their current financial situation as where they are. And that's usually just the base difference right there.
So you'd have a caretaker and a trustee for both of those?
Mm-hmm. Yeah, so you would have, still those roles would be present in either of those options, okay? So in your will, you can name a caretaker or trustee, and in a living trust, you can do the same, okay? Also, within a living trust, the other benefit to doing a living trust is that it has a little bit more flexibility in that you can set up one big trust. It doesn't have to just be for your pets. It can be for your entire family and all your family members, and only a portion of it is used for your pets. Okay, so it just directs, however much you want to put aside can all be included in that one document. If you have a number of other family members, kids, grandkids that you want to provide for, it can all be done in one big document. Okay, sure.
I have a living trust. If I want to do a change, I just do it by amendment. Is that what I would do? Or I have to change the whole?
Generally, yes. So the good thing about living trusts is that usually they're very easy to amend, and usually doing an amendment is not necessarily a ton of work for the attorney drafting it. The caveat to this is that I don't have your documents in front of me, so what I usually, if someone comes to me with a living trust, I want to read the whole thing first to make sure that it's, one, that it was validly executed, and two, that it complies with my client's current wishes. That it, because I want to know my client's goals and make sure that what they have in place at least somewhat accomplishes the goals that they have. And so that way, if that is the case, then a minor amendment might be the right course to take. If it's, unfortunately, sometimes I've seen this where it's a very poorly drafted document, and I recommend we just start over and do a brand new one, but that's usually not the case. Usually it's just doing an amendment, which is pretty easy to do, and it's not a ton of work as far as I'm concerned.
How much does a pet trust cost?
If you're looking at just the trust itself, or the trust, if it's a couple, it's going to be more, and then it basically goes up from there depending on how complex it's going to be. Okay, and then the wills, if you wanted to do wills, it's a little less than that, but everything is still kind of in the same range.
As you talked about a living trust being something that then you can be the administrator of as far as the investments until you die.
Mm-hmm.
I'm assuming a place like Schwab or Fidelity then could be where then the actual assets are maintained.
Yes. So essentially what you do is if you wanted to set up, like you create a trust, you can actually set up a trust account at any financial institution, and that's where the funds are held. But you as trustees still have the control over them. So the financial institution just holds them. They don't have any control over them unless you name a corporate trustee. Okay. Unless you say, I want Chase Bank to be my trustee, then they have control over the assets. But yes, so otherwise it's just a regular account, like an investment account that's held at a financial institution.
Right.
Mm-hmm.
Is there anything, I guess, if you wanted your pets to go to a humane society, is there some kind of formal document that you would leave with that society or organization in advance to assure yes, indeed, they would accept your, pets at the time of your life.
Yes, well, I always recommend that they contact whatever society they're talking about first. One, to see that this is something that they do and this is the type of animal that they do accept. Some places have restrictions on what kinds of animals they can take in and what kinds they can't. So I usually recommend that you contact the actual society first, and then it's usually depending on them what they like to have as far as specific documents or forms. I don't know if you guys have any input on that.
We just had that situation happen where a gentleman asked us to take his cat. He put us in his will, but he passed away and we were not notified. We did take the cat, it was in his will. And then he left us a sum of money for taking the cat, and when he got adopted, he actually gave a sum of money to the person that adopted the cat as well. So, but it would be nice just to have a copy of the will at least to know that we were gonna, that could be a possibility.
Yeah, I was wondering, like, in some cases, like, a few years back, I was socializing some kittens, and because the economy was so bad, so many of the humane societies wouldn't take any animals in, so I was just kind of concerned, you know, if there isn't space available,
Right.
what would happen?
What we would do if that was the case is we would find a foster home to take the animal in. There would be certain limitations, but again, it's very specific, like feral cats, for instance. Our shelter just doesn't have the means to take those in, but we work with groups in the area, and we would try to accommodate the request that way by having another group help us out that does that.
And it wouldn't necessarily have to be a cat adopted from us?
No, it wouldn't.
Do cats that are adopted from the Humane Society, are they welcome back?
We always take our animals back for whatever reason, so absolutely, yes.
Yeah. And that's the case with, I think, with many of the organizations, at least that I've encountered, have similar policies of being willing to take back any animals that have come from there in the first place.